Good afternoon. Today I'm going to look at a banal topic, I suppose, in a way, but one which is of fundamental practical importance and one that arises every day of the week in the company's list in terms of applying for security for costs. You've got an indigent plaintiff against you, you want to stop them from proceeding. What do? Whack on straight away an application for security for costs, a couple of tranches, and you may well stop them from proceeding depending on how much you're seeking. That's a cynical view, but I guess that's what often is behind security applications. On the other hand, of course, if you've got someone who's not likely to be able to pay your costs, I guess you're entitled to be protected in the event that you win and they can't satisfy the costs against them. Well, what's the source of jurisdiction? Jurisdiction's got two bases, you should recall. First of all, we've got section 1335 of the Corporations Act, and then we've got UCPR Rule 42.21 1D. They both provide pretty much the same sort of thing in terms of security. Dealing with corporations, of course, here, not individuals. And Corporations Act, section 1335, says that where a corporation is a plaintiff in any action or other legal proceeding, the court having jurisdiction in the matter may, if it appears by credible testimony that there's reason to believe that the corporation will be unable to pay its costs of a defendant if successful in his, her or its defence, require sufficient security to be given for those costs and stay all proceedings until the security is given. There you go. And UCPR is in the same sort of terms for Part 42, Rule 21, New South Wales, 1D. If in any proceeding it appears to the court an application of a defendant, the reason to believe that a plaintiff, being a corporation, be unable to pay the costs of the defendant is ordered to do so, the court may order that security be given in such manner as the court thinks fit for the defendant's costs and the proceedings be stayed. So there we are. We've got a wide discretion, of course, in determining whether or not security for costs should be granted. And we've got lots and lots of cases on this, so we won't go over them all today. But a recent useful case to look at with respect is Justice Beasley, President Beasley, of course, as she now is Margaret Beasley, in Golden Mile Property Investments in liquidation in Cudgegong, Australia, 2014 NSWSC 224. Useful case to look at in terms of summary. And also, more recently, we've got Justice McDougall in ILC Group and Sydney Water Corporation, 2014 NSWSC 1407. And that's that case I'll look at more closely today, ILC Group, because interesting decision. In that case, the people standing behind the company, the individuals, offered to put up a guarantee with respect to the likely costs, even though the company was simply a $2 company. And Justice McDougall looked at how much money they would generate, how much money they could pay, and points out in paragraph 28 in ILC that there may once have been a theory that to defeat an application for security in the context of the plaintiff being a company was unlikely to be able to pay them, it was sufficient for the directors to, as it were, step out from behind the skirts of the corporation and bring their own assets into play. So he says in paragraph 28, in other words, you offer to stump up yourself personally. But he points out that if that were thought once to be the applicable principle regulating the fate of applications, it's not so regarded now. Most more recent cases stress the discretion to order security is relevantly unconfined, the only restriction, if it is one, being that the discretion is to be exercised judicially. The point was made very clear in a number of cases, and the authority is to 2007, reviewed by the Court of Appeal in New South Wales in Jazabas, Jazabas, Proprietary Limited, and Haddad, Haddad, which is in 65 ACSR 276. So there you go. An earlier case, key case is, funnily enough, one of Justice Beasley's earliest ones, I think, in KP Cable, CABLE Investments, and Meltglow, nice name, 1995, 56 FCR, Federal Court Reports, 189 at 196 to 198. And when you look at that decision, Justice Beasley, that's a decision from a fair while ago, 20 years ago, which sets out very compendiously the basic principles that one must look at. And it summarises them in some detail. What are the basic principles? Well, first and foremost, you've got to bring the application timeously. You've got to bring it promptly. Righto, equity helps those who are alert, not asleep. Vigilantibus non dormientibus. Right, don't wait, don't let the matters run ahead, because of course in the interim period, the party who is suing you will be running up costs. So if you're going to bring an application, you've got to bring it promptly. Doesn't really matter, but in fact some costs have already been incurred. It's a matter of discretion, but bring the application as promptly as possible. Key point. Get into action early. Secondly, have a look, as the court will, at the strength and bona fides of the applicant's case. As a general rule, if a claim is prima facie regular and discloses the cause of action in the absence of evidence to the contrary, the court should proceed on the basis the claim is bona fide and with a reasonable prospect of success. Okay, so have a good look at it. If it looks like one of those unlikely claims, I guess you move to strike it out at the same time as you move for security. You say this is all rubbish, let's get rid of it right now. Thirdly, you've got to consider the applicant's impecuniosity. Was it caused by the respondent's conduct, which is the subject of the claim? Alright, so the party which is suing, the plaintiff as it were, was the fact that they're out of cash, the reason that they can't now provide security, and that's why the lawsuit's been brought. Impecuniosity, an important question. And allied to that is the question of whether the respondent's application for security is oppressive, in the sense that it's being used merely to deny an impecunious applicant a right to litigate. Yes, well you can't do that because it's not appropriate to, as Justice Clark said a long while ago, to use this application to frustrate the plaintiff's right to litigate its claim because its financial condition does not automatically lead to the refusal of an order. Then point 5, important one in terms of ILC, of course, with Justice McDougall. Are there any persons standing behind the company who are likely to benefit from litigation and who are willing to provide the necessary security? Important point. We've got $2 companies, Salomon and Salomon. We can't pierce a corporate veil. I guess it's always a balancing exercise for capitalism. Is it good that you can simply walk away from a company having paid up the capital, which is usually $1 or $2 in most cases with private companies, and start again, leaving the liquidator sort through the mess? Well, people do that, of course. We've got all sorts of inquiries about Phoenix companies going on, etc., etc. Similarly here, if you're seeking security for costs, are those who are in fact standing behind the company using it as the vehicle, quite properly of course, are they going to provide some security? And are they able to demonstrate from their resources that they will be able in fact to meet an order for security? Important question. And an issue related to that is whether the person standing behind the company have offered any personal undertaking to be liable for the costs, and if so, the form of any such undertaking. Well, another important point. Then, final point perhaps, security will only ordinarily be ordered against a party who is in substance a plaintiff, and an order ought not to be made against parties who are defending themselves and thus forced to litigate. Basic rule, if you're being forced to litigate to defend yourself, then an order should not be made against you. Well, in ILC, Justice McDougall looked closely at all the various points. There was a reasonable case that was being argued, that was being put, some force and proposition. People were suing Sydney Water. They'd said that they had to put on some expert evidence. The company itself couldn't afford it, but the individual directors, as it were, standing behind it, were prepared to stump up the money. No submission, paragraph 41, that the defendants brought the application purely as a tool or device to shut that plaintiff out of its litigation. So it wasn't oppressive in that particular sense, no sense of oppression there, trying to shut people out. But question, of course, as to whether or not in this particular situation they should order the party standing behind it to, if you like, fortify their obligation. And they had assets that they could look to do that. They had a house and various other interests they could put in. And Justice McDougall says, Bob McDougall says at paragraph 51, competing interests raise a question of considerable difficulty. On the one hand, the plaintiff has what I accept as a claim in good faith, reasonable prospects of success. It will cost a considerable amount to prepare and run. On the plaintiff's view of the world, the costs that's incurring to prepare the case, at least in terms of a measurement exercise, the costs that should have been incurred by the defendants already in the performance of their contractual obligations. But put against that, of course, was the proposition that there wasn't sufficient assets available to satisfy the question of risk as to costs if they lost, paragraph 52. So, difficult question. Allied to this, lurking in some of the cases, is the question of whether or not a smaller corporation, such as the plaintiffs in ILC, should get a more favourable run. Difficult question, of course. All corporations are equal in a theoretical sense, but what if you're a small corporation, husband and wife enterprise, directors, small capital, and you're battling against BHP or Telstra? Well, we've got some authority on that. Justice Rary's in a recent case, Top Stuff for Business Holdings and Vodafone, 2012, Federal Court of Australia, 645, at paragraph 8, looks at earlier decisions in terms of large versus small corporations, drawing on something Justice Baston said in an earlier Court of Appeal decision. Justice Rary said it may be that when security for costs is sought, a court will be more sympathetic to a small corporation with limited funds as opposed to a major corporation. But Justice Baston in the earlier case said that large corporate defendants should not be seen as standing outside the policy behind section 1335. And its analogies, they stand in no special need of care and attention, and John Baston said it might be seen as oppressive to allow a large corporate respondent to obtain an order for security beyond the capacity of a corporate applicant or plaintiff to pay, so it was more like to stifle litigation for the claim of potential merit. And the quantum of costs, this is the key point, would in any event be a relatively insignificant amount for the corporate respondent. And in that case, we may be looking at oppression, I guess, in the broader sense. Well, here, Justice McDougall looked at the various issues, summarised all very detailed judgment, well worth reading, as with respect to whatever His Honour says is on these practical matters. He knows a lot about the practice. And in paragraph 59 he says, in the present case, it seems to me that there's a real risk that if security is ordered, the litigation will be stifled. And there's a frank disclosure, the assets available, and then it was said that there'd be unlikely to be a bankruptcy, even if they were forced to take all the assets out of the equation. But at paragraph 63 he said, I accept that the mere fact of an offer of a guarantee of personal liability is not sufficient to meet application for security. Paragraph 65, balancing those factors and taking into account the judgment of Justice Beasley and KP Cable, I conclude that this is sufficient justice as to security if the applications are dismissed on the basis that the individuals have given the guarantee to which I referred and the undertaking to the court to which I have referred. Reaching that conclusion, I proceed on the express basis that the promise to deal reasonably with any requested changes to the wording of the guarantees will be honoured. Well, there you are. Interesting case. It's interesting, I think, one of thousands of cases, of course, but interesting because it summarises pretty conveniently all the relevant principles. And it's clear that the courts often face a difficult question, particularly with a small and underfunded plaintiff company being faced by a large one as to whether or not there should be any security ordered. Cases come on day after day, thousands of them out there. Have a good look at the principles. I guess if you're going to do anything, act swiftly, as they say in the commandos. Don't wait around. Get into court promptly if you're seeking security, and seek a reasonable amount, and at the same time, if the case is no good against you, then I guess move to strike it out.